Welcome to the Understanding Education Civil Rights Issues Workshop. My name is Dr. Gwendolyn Kelly, and I am an educational consultant and community advocate, and I will be your moderator for this session. Here are some few housekeeping rules before we start. As you listen to the presentation and you have questions, please type your answers in your questions in the Q&A box. The questions should relate to the topics we are discussing. We will get to as many of the questions as possible during the last few minutes at the end of the session. Also, as the session ends, you will be redirected to complete a survey about this session. Please complete the survey session questions because your answers are important and are instrumental in helping the IBE team with planning next year's conference. Now, help me welcome our presenter, Mr. Tim Schultz. Tim Schultz currently serves as Deputy Director and General Counsel of the Indiana Civil Rights Commission, ICRC. The agency is charged with enforcing the Indiana civil rights laws and provides education and services to the public in an effort to ensure equal opportunity for all Hoosiers. Mr. Schultz has served Hoosiers since 2008 in various capacities. First, by representing the state before the Indiana Tax Court and the Indiana Supreme Court for a combined 7 years with the Office of the Attorney General and the Indiana Department of Revenue. Immediately prior to joining ICRC, Mr. Schultz served as the General Counsel for the Indiana State Board of Education. Over the course of more than 4 years with the board, Mr. Schultz provided counsel to the board members on a variety of topics, including school accreditation, assessment, and academic accountability issues, grant programs, and virtual education. In his capacity as General Counsel for the board, Mr. Schultz also had the opportunity to work with policymakers to assist in the development of education initiatives and future grants. Also in his role at IRCR, Mr. Schultz oversees the agency's complaint intake, investigations, alternative dispute resolutions, and the litigation divisions, as well as coordinating agency efforts with the Department of Housing and Urban Development and the Equal Employment Opportunity Commission. In this capacity, Mr. Schultz works to ensure Hoosiers have an equal opportunity for education, employment, access to public accommodation, and fair housing in accordance with the state's civil rights laws. And now, Mr. Tim Schultz.
Good morning, and thank you, Dr. Kelly. It's a privilege to be here with you today. My name, again, is Tim Schultz, and I'm the Deputy Director and General Counsel for the Indiana Civil Rights Commission. And today, as the title of the presentation suggests, I'll be presenting on understanding educational civil rights issues. And if you give me just one moment, I will bring up my presentation. Okay. So before I begin, I always like to start off with a brief disclaimer. The ICRC does not make the laws, we simply enforce them. Please do not consider anything I say today as legal advice. For legal advice, please contact an attorney. And this presentation provides general information and guidance and is not to be considered official ICRC policy. So today I'll be discussing the ICRC mission, jurisdiction, operations. I'll be discussing what is unlawful education discrimination, and I'll be concluding with some food for thought, suggestions, ideas, and then of course we'll be opening it up to questions. So what is unlawful discrimination? Discrimination is the prejudicial treatment of an individual based on their membership or perceived membership in a certain group or category. It involves the actual behavior towards groups, such as excluding or restricting members of one group. In short, treating someone differently or unfairly because of their protected class is likely an unlawful form of discrimination. And I always like to point out when I'm presenting about what the ICRC does and what discrimination is by saying that from a legal standpoint, discrimination between individuals is lawful unless it's prohibited by law. So for example, an employer may discriminate between applicants because of a level of education or work experience. That is permissible because it's not prohibited by law. Or with housing, for example, a landlord may, generally speaking, discriminate against applicants on the basis of their creditworthiness. Again, unless it's prohibited by law, this is a form of permissible discrimination. Under Indiana law, discriminatory practice is the exclusion of a person from equal opportunities, a system that excludes persons from equal opportunities, or the promotion of racial segregation or separation in any manner based on an individual's protected class. The Indiana Civil Rights Commission enforces Indiana Civil Rights Code, which can be found in Indiana Code 22-9, and the Indiana Fair Housing Act, which is found in Indiana Code Title 22, Article 9.5. The jurisdiction for the agency extends to individuals, private or public entities, housing providers, and business establishments within the state of Indiana. The Indiana Civil Rights Commission mission is the neutral investigation of complaints with the goal of eliminating discrimination against protected classes in the enforcement areas designated to the agency by Indiana law, which I'll be discussing in a moment. And I always like to emphasize the neutral investigation. The ICRC doesn't represent one side or the other. Our goal is to determine the facts concerning a particular complaint and do so in a neutral manner. But in short, the agency protects you from discrimination. That's in a nutshell, that's our goal. As I mentioned before, there are certain protected classes that are identified in Indiana law. Those protected classes are listed on the screen. They include race, religion, color, sex, disability status, national origin, ancestry, familial status, veteran or active duty status with the military, and age. Not all of those apply in every situation. For example, familial status is unique to fair housing complaints, but those are classes that have, or protected classes that have been identified in Indiana law. Next to that, you'll see the enforcement areas that the agency has authority to investigate. Those include fair housing or real estate, employment, public accommodations, education, and credit. So briefly, an overview of the agency. The agency receives complaints or inquiries in our intake division. That those intake specialists work with complainants to help them draft a complaint, which of course, and then in certain situations, if we don't have jurisdiction, we will assist those individuals as best we can by perhaps referring them to another agency or providing other resources. If a complaint is valid and timely, then that will be sent to one of our two investigation divisions. We have an employment investigation division and a REPACE investigation division. REPACE standing for real estate, public accommodations, education, and credit. All of that is in-house, and those investigators have the authority to conduct interviews, request documentation, and issue subpoenas in accordance with Indiana law. If that investigation determines that there is a no cause or there was no actionable discrimination, then the matter is concluded. Alternatively, if there is a cause finding made by the investigator, the complaint and that file then go on to our in-house litigation team. Our in-house litigation team will litigate the matter on behalf of the public interest. Again, we don't represent the complainant, we represent the public interest. That litigation might occur before an administrative law judge or before state court, depending on if the parties elect to do so. The ICRC is somewhat unique in that respect, that we are allowed to conduct our own litigation under Indiana law. Many agencies don't have that authority, and in fact, many other state agencies similar to what we do have to rely on outside legal organizations. So we're rather fortunate in that respect. Additionally, Parties may engage in alternative dispute resolution at any time, either during the investigation, after the investigation. And what that allows for is the informal resolution of a complaint based on terms agreeable to the parties. And that could include a monetary settlement. It often includes training. I have found that in many instances, individuals discriminate not intentionally, but unintentionally, and it's a result of not understanding what the law is. So that's why training is always such an important component. And again, all of that's done in-house. We're really a one-stop shop. And of course, it's free services to the public. So what does the law actually say about education? Well, as you can see there, Indiana Code 22-9-1-1 clearly states, quote, "It is the public policy of the state to provide all citizens equal opportunity for education." Obviously, the statute continues on to identify those other areas I've mentioned, but of course, we're focused on education today. So the Indiana Civil Rights Law declares equal education to be a civil right and provides that it is a public policy of the state of Indiana to provide equal opportunity for education. Well, what does that mean? What is unlawful education discrimination? As I noted, everyone has the right to get an education free from unlawful discrimination. Such discrimination is prohibited by Indiana law, which prohibits the denial of equal opportunity education or receiving a lesser education due to the student's protected class. So where can unlawful education discrimination occur, and who can commit that kind of discrimination? As far as the where, education discrimination can happen in public and private schools, colleges and universities, in trade schools, or professional or business schools. So essentially, it's the law casts a fairly wide net as far as where discrimination might occur, or unlawful discrimination, I should say. As far as who, the actions of a student, teacher, administrator, or other school employee may be considered discriminatory, or a school's policy or how it's applied may be discriminatory. The victim may not be one individual, but a group who is negatively impacted by that policy or actions. So, it's always important to note how did most of the modern laws that we deal with come to be. As I'm sure many of you know, in the 1954 Brown v. Board of Education decision from the United States Supreme Court, the court held that segregation of students in public schools on the basis of race deprives students of the minority group of equal education opportunities and is a violation of their constitutional rights. There's a quote from that decision that I always like to emphasize, because I think it's just really it's important. It's hard to argue with, and that quote is, "It is doubtful that any child may reasonably be expected to succeed in life if he or she is denied the opportunity of an education." I've always found that to be a powerful statement, and anytime I'm working with an education case, that is always in my mind. So after the Brown decision, numerous federal and state laws were enacted. Those include Title IV of the Civil Rights Act of 1964, which prohibits discrimination based on race, color, national origin, sex, and religion in public schools and institutions of higher learning. Additionally, Title VI of the Civil Rights Act prohibits discrimination based on race, color, and national origin by recipients of federal funds. Title IX of the Education Amendments of 1972 prohibits discrimination based on sex by recipients of federal funds. Section 504 of the Rehabilitation Act of 1973 prohibits discrimination on the basis of disability by recipients of federal funds. You might be seeing a pattern here that, at least at the federal level, that the prohibition of discrimination is usually linked to the receipt of federal funds. The Equal Education Opportunities Act provided resources to ensure English learner students are given appropriate services. Title II of the ADA prohibits discrimination based on disability by state and local entities, including schools. Then finally, at the state level, the Indiana Code, Title 22, Article 9, which of course I've already referenced as far as providing equal opportunity for education to students. So what does discrimination in education environments actually look like? There's three general categories that we see. The first being disparate treatment, which is when an entity treats people in a protected class differently than others not in that class. I'll be going out into some examples in my next slide, but that's really probably the simplest type of discrimination and probably what people think of when they think of discrimination. So, if a company or a school says, we don't allow individuals from a particular protected class to participate in or work for them or participate in that school's activities, that's a very straightforward form of discrimination, which is what we consider to be disparate treatment. Disparate impact is a little more difficult to identify. That's when an entity employs a facially neutral rule, policy, or practice that results in different outcomes. I think, and again, I'll go into some examples to talk about that more, but the focus of that type of possible discrimination is it's a focus on the results of the rule or policy. So there might not be any intent to discriminate against any particular protected class, but the outcome of that rule or policy shows a disparate impact on a protected class. And then the third category is refusal to provide reasonable accommodations and modifications. That's when a person with a disability seeks a change or exemption to a policy modification of a structure or program, and the request is denied. And the difference between accommodation and modification is an accommodation is a change to a policy asking for an exemption, for example, whereas a modification is often a physical change to a building or a change to a particular program. So some simple examples of those types of discrimination. Example one, Acme School has a policy that will not accept students who have a disability. This is probably a pretty clear-cut example of disparate treatment because the policy directly implicates people in a protected class, specifically individuals with disabilities. Example two, Acme School has a policy that it will only admit students that achieve a certain score on a standardized test. This could be an example of disparate impact discrimination. The rule appears to apply equally to everyone. However, persons in a protected class may disproportionately not achieve that desired test score. Thus, the result of the policy is that individuals in a particular protected class are being denied access to that school at a disproportional rate. And then the third example, Acme School has a quote, no animals allowed, end quote, policy. And a student with a visual impairment requests an accommodation to allow the student's assistance animal to attend classes with the students, which the school denied. This appears to be an example of a reasonable accommodation request that was improperly denied and could be considered a form of unlawful discrimination. The general rule is that any reasonable accommodation or modification request should be granted. And I'll discuss a little bit later about when a request would be considered unreasonable. But those are just three simple examples to kind of give you an idea of the types of discriminations you see in an educational environment. So what I'm going to be doing is focusing on some recent legal developments concerning equal access to education. Those four areas have been identified here as determining if a student disability issue is subject to civil rights protections or protections provided under other laws. Second, discussing COVID-19 and equal opportunity for education issues that, of course, continue to be with us, even though we've made a lot of progress. Third, does harassment violate the right to equal opportunity to education? So peer-to-peer harassment or even harassment that a student might receive from an employee of the school. And then fourth, discussing linking alleged discriminatory acts to equal opportunity for education. And that's just going to be a brief discussion about some Indiana case law that's looked at the issue of what it does mean for equal opportunity for education. What does that mean here in Indiana? So the first topic, we're talking about recurring issue when considering the accommodation modification requests in an education setting is the question of whether the issue is governed by the Individual with Disabilities Education Act, also known as IDEA, or does that issue fall under some federal or state civil rights law? This has been something that's gone back and forth in the courts for many, many years, and the U.S. Supreme Court recently looked at this issue in the Fry v. Napoleon Community Schools case from 2017. In the Fry's decision, the Supreme Court explained that IDEA guarantees individually tailored educational services, while the Americans with Disabilities Act or 504 of the Rehabilitation Act, so the federal civil rights laws, are designed to ensure non-discriminatory access to public institutions, sometimes by means of reasonable accommodations or modifications. So what does this mean? Educational services versus access to education. Those are, but a lot of people might say, like, I don't know what the difference is. So IDEA ensures that an eligible student can acquire substantive right to free, appropriate public education once the state accepts IDEA's financial assistance. That student is then entitled to meaningful educational services based on that student's individual needs. So how they're being taught, what they're being taught, that's the educational services. Alternatively, if we're dealing with a civil rights issue, those laws are designed to assist a student attempting to address an issue concerning access to education. The complaint might have, if we're talking about access to education, we don't necessarily need to worry about the administrative requirements and procedures that are associated with IDEA. Instead, we're talking about access, and that's governed by a whole different area of law. So in the Fry decision, the Supreme Court took a fairly pragmatic approach, explaining that when determining if a disability-related concern falls under IDEA or civil rights laws, one should consider the following. Look to the crux of the gravamen of a complaint, or as I like to say, it's not everybody understands, like what's a gravamen. Consider the substance of the complaint, regardless of whether the particular labels or terms that are used in that complaint. Whether or not a complaint, specifically uses terms such as, individualized education program or IEP, or talking about access to public education, the court was very clear in that it's not how you describe your concerns or the issue. It's what that student is trying to obtain. So in other words, the analysis should not be a gotcha review, where the use or the lack of a term in the complaint dictates how that complaint's going to be managed, but either under the IDEA or civil rights laws. And I think that was probably a very intentional decision by the court to ensure that we're looking at the substance of the complaint. What is that student trying to obtain? Furthermore, the Supreme Court offered two questions to assist when determining the appropriate set of laws to apply. And the two questions are, could the same complaint be alleged in a non-school setting? And could a non-student, likely an adult, raise the same complaint in a school setting? If the answer to these questions is yes, the complaint is unlikely to be about educational services and subject to the IDEA laws and procedures. If the answer to these questions is no, then the complaint probably does concern educational services, even if it's not clear from the terminology or the phrasing of that particular complaint. So for example, kind of an easy example, and I think this was the issue in Fry. That a student would like to have their service animal with them throughout the school day, so on the premises of the school. Well, that issue, and of course, and the school denies that request. Well, could that complaint be alleged in a non-school setting? Sure. Individuals take service animals to their places of employment, and often require an accommodation to do so. But also service animals are allowed into public accommodations areas. So individuals can take their service animals to grocery stores or theaters. So the answer to the first question, could the complaint be alleged in a non-school setting, would be yes in that scenario. The second question, could a non-student raise the same complaint in a school setting? Well, yes. An employee of the school, so a teacher, may have a visual impairment and need an assistance animal. Again, the answer to that is yes. And in that scenario, it seems likely that that issue would fall under the civil rights laws as opposed to IDEA, because it's something that could arise in or out of the school, and it's really addressing, or it's dealing with that access to education, that issue of access. Going back to the Friday decision, the court ultimately determined that the lower court applied the wrong standard for determining whether the substance of the complaint fell under IDEA or the civil rights by broadly saying, well, it's educational in nature, so it falls under IDEA. Supreme Court ultimately reversed that and came up with the test that I've, of course, been discussing here today. Of course, it's never quite that simple. There's always unique scenarios, so courts have continued to take into account other considerations, which fall into four broad categories that I've listed here. The first being whether the student initially sought a remedy or relief under IDEA or civil rights law prior to seeking under IDEA prior to seeking alternative relief under a civil rights complaint. Sometimes courts look at, what was their first action, because that might kind of explain what they're really trying to get. But of course, that's not always indicative, as the Supreme Court acknowledged. The second consideration that courts sometimes consider, and although not universally accepted, if the type of relief sought by the party is available under IDEA. So, for example, monetary relief or a modification to the building would be examples of things that are not necessarily available under IDEA. So if a student was, who used a wheelchair requested that the school build a wheelchair ramp so that the student could access the building, that type of relief is something that would be more appropriate under civil rights versus a student requesting a change to their learning program or the amount of time that they are being taught a particular subject. That would more likely fall under IDEA because they're talking about the educational service being provided to that student. The third consideration is, does the complainant identify an issue of physical access or removal of barriers, or does it seek to implement the student's education program? Again, that's very similar to that second consideration, but again, we're just talking about access. Is it access or service? And then that fourth consideration is whether or not the complaint identifies a systematic discriminatory practice. Some courts, and again, this is not all courts, have reasoned that in an IDEA suit seeking systematic relief, no plaintiff need exhaust administrative procedures because such exhaustion would be futile. To fall under this exemption or exception, the alleged violations must be truly systematic in the sense that the IDEA's basic goals are threatened on a system-wide basis. Again, these are just considerations some courts review or consider, not all courts. And the default, of course, is to go back to the Fry decision, look at the substance of the complaint, and consider those two questions. So we've gone through that whole analysis, and now the question is, if the allegation, in fact, asserts a civil rights claim, what's the next step as far as addressing that student's reasonable accommodation or modification request? Recent case law from the Seventh Circuit have identified 3 items that the court should consider. 1, whether or not the student suffered from a disability. 2, was the student qualified to participate in the program in question with or without the accommodation? And 3, was a student excluded from participating or denied the benefit of a program based on the disability? I think it's important to note that based on civil rights case law in areas such as fair housing employment, there's usually also a requirement that the allegation identify that the students, provided notification and that the school engaged in some sort of process. Those are typically factors found in other areas of civil rights laws, even if it hasn't been necessarily identified by the Seventh Circuit. And of course, the question of whether a requested accommodation is reasonable is highly fact specific and requires a balancing act for the needs of the parties. As I mentioned before, not all accommodation requests are reasonable. A proposed accommodation is unreasonable, according to the federal guidelines, if it imposes significant financial or administrative costs, or it fundamentally alters the nature of the program or service. So, for example, a fundamental alter of a service was discussed in a federal court decision where a student with a disability asked that the qualifying times for a sporting event be revised or changed to account for the student's disability. And the court ultimately said this was an unreasonable modification to that program because it changed the qualifying standards for all participants, which was a fundamental change. But again, I always like to reiterate, as a general rule, reasonable modification, accommodation, request should be granted. And it's just a good, it's a good practice to always make sure that you acknowledge such a request and discuss that student's needs. Otherwise, you're more likely to create some trouble for yourself. And of course, nobody wants that. I mean, at the end of the day, I think everybody really wants students to have access to education. Again, going back to what I said earlier about providing training during our mediations, I firmly believe that most discrimination is not intentional. People just don't understand what the laws and the requirements are. So that's why I just want to emphasize that need to engage a student when they make such a request. Okay, so on to our second topic, COVID-19 and equal opportunity to education issues. So despite the continuing public health concerns resulting from COVID-19, students in protected classes are still entitled to equal education opportunities in a safe environment. School officials must ensure that any actions or policies taken to implement safety measures are based on actual risk without reliance on assumptions, stereotypes, or are applied in an inconsistent manner. So essentially what I'm saying is, despite the unique challenges that COVID-19 has created for schools and school administrators, all of the laws still apply. So when I just went through the analysis for students with disabilities, as far as reasonable accommodations and those services, all of those laws still apply and protect students, and of course they apply for every protected class. Some examples regarding that second point there about the application of policies being based on actual risk or not being based on assumptions or being inconsistent. An example where a school might want to be very careful about is if it inquires about recent travel of students, but only doing so of students of a particular race or national origin. If you're going to have a policy where you're inquiring about student travel, that policy will need to be applied consistently to any student that falls within that policy. You can't, once you start treating a protected class differently, you're likely to run into some trouble. Another example is treating students differently by any means, simply because they or their family members were born or have ever lived in a country that's still experiencing widespread COVID-19 transmission. This all just goes back to making sure you're treating every protected class equally. Inconsistent policies are probably the number one thing that we've seen over the last year as far as creating civil rights issues. Consistency is, I just can't overstate it. So sticking with that theme of policies, well-intentioned policies can still create possible civil rights issues. So unintended consequences of data requests related to health and safety policies that a school might have. Schools should consider if the information they're requesting from students pursuant to whatever policy may chill or discourage the participation or lead to the exclusion of students in a particular protected class. For example, data requests that could be perceived as related to citizenship or immigration status may have a chilling effect. One tip that I think schools have adopted is reviewing enrollment data on a regular basis. Significant drops in the enrollment of any particular protected class may indicate you have a policy that's having a disparate impact on that class, even if that's not the intent. But that policy might have a chilling effect that the school just didn't anticipate. Second, imposing facially neutral policies when providing distance learning assistance, school meals, or other educational resources in order for students to access those resources. It is certainly understandable that a school would want to be sure that it is providing meals to the intended student or student's family, or ask that all students receiving distance learning resources, such as a computer, provide validation of the student's residence or evidence of internet access. The issue is that imposing such requirements may have a disproportionate impact on protected classes of students. Again, kind of going back to that chilling effect, if you're asking for individuals about proof of residency, to have access to a computer or access to free or reduced price meals, that might have a chilling effect on a particular protected class of students. So maybe instead of a policy like what I just described, the school rather than asking about evidence of internet access, it just ensures that it has learning programs that can monitor student participation. That way, that policy is much less likely to have a discriminatory effect on any protected class, but it still allows the school to identify if the student is accessing the learning resources. Then third, standardized policies targeting students with disabilities. Generally speaking, standard policies for students with disabilities that do not include individualized decision-making processes may increase the risk of a student's access to education being impacted. This really is, there might be a policy, some sort of safety policy that's designed to ensure students with disabilities are their risk of being exposed to COVID-19 are reduced. The problem that you see there is, or that you may see there, is if there's no individual decision-making component of that particular policy. Especially in the area of students with disabilities, one-size-fits-all policy is often going to lead to possible civil rights issues. So it's always important to have an individualized decision-making component. That brings me to my third topic, whether harassment constitutes a violation of a student's civil right to equal opportunity to education. Although there are relatively few decisions regarding this topic, court decisions, I should say, it does appear that harassment could constitute a violation of a student's right to equal opportunity to education under Indiana law. What does that mean? I mean, harassment, what qualifies? Are we just talking about bullying? Are we talking about, looking at somebody a funny way? And what is the school required to do if they become aware of that? So generally speaking, a school must respond to harassment based on a protected class, and which also creates a hostile environment. That harassment might include verbal attacks, such as racial slurs, graphic and written statements, name calling, or physical threats or acts. For example, this could include harassment targeting a student because of the student's race or actual or perceived ancestry or ethnic characteristics. And question of whether or not a hostile environment's been created. A hostile environment occurs when the harassment denies or limits the student's ability to participate in or benefit from educational programs and activities. For example, offensive comments about the race of a particular student that leads to decreased class participation by that student could constitute evidence that a hostile environment has been created. And I think, especially these days with remote learning, it's important that school administrators be mindful that this can occur just as easily in remote learning environments as it can in person. So some key factors to including whether the harassment is based on a protected class and the activities created a hostile work environment. Oh, I'm sorry. I'd like to back up. So what does a school need to do, or what a school administrator need to do if they become aware of a situation? Well, every situation is unique. It's prudent for school administrators to do the following if they become aware of discriminatory harassment. First, to take prompt, effective, and appropriate steps that are reasonably calculated to end the harassment. Second, the administration should take steps to address the harassment's effect, eliminate the hostile environment, and prevent harassment from reoccurring. This may include separating the parties, providing training or counseling to the parties, and possible disciplinary action for the alleged harasser, though of course always being mindful of any due process rights that might apply to that disciplinary action. Furthermore, depending on the extent of the harassment, schools may consider providing training or other interventions for the entire school community. Just depends on the scenario. Like I said, every scenario is unique. Presuming an allegation of harassment claims that the behavior was based on the student's protected class and created a hostile environment, what is the standard to prove a civil rights violation has occurred? Generally speaking, again, every situation is unique. I always like to emphasize that these are some general guidelines, but every situation requires unique analysis. School officials are given broad latitude to resolve peer harassment and are liable only in certain limited circumstances. In order to demonstrate a student's right to equal opportunity to education has been violated by a harassment claim, the student would likely need to show that the harassment was discriminatory based on that student's protected class, that school officials had actual knowledge of the harassment, that the harassment was so severe, pervasive, and objectively offensive that it deprived the student of access to educational opportunities, and that the school officials were deliberately indifferent to the harassment. So it's not simply somebody was, the student was called a particular slur or something, and that was it. The school officials need to be made aware of it and essentially just take no action. But courts have also been quick to point out that school administrators are probably not going to escape liability by putting their heads in the sand. If you just ignore the problem, you're likely to have a civil rights issue. Then the question that often comes up in these scenarios, because the student's being harassed, so what if they report that? If they file a complaint with the ICRC? Well, retaliating against a complainant or anybody who even assists with an ICRC investigation may give rise to a separate agency action and judgment. According to Indiana law, filing a complaint is a protected right, and assisting in an ICRC investigation is again protected by law, and to retaliate against somebody for filing or assisting is likely to give rise to another complaint and separate investigation. So final thought, the importance that a complaint link the alleged discriminatory act to educational opportunities. So a lot of what I've been discussing has been federal case law analysis, considering federal civil rights laws, which the Indiana laws are substantially similar to. Of course, there's some differences, and looking at some of the Indiana case law that has looked at unlawful education discrimination. Those cases have repeatedly noted that the complaint needs to link the discriminatory act to the educational opportunities. So in a Court of Appeals decision a few years ago, the court held that ICRC did have jurisdiction over a student's complaint of racial discrimination for not being admitted to play on a girls' varsity basketball team. We were dealing with a private school. It was not a public school, and the school argued that it was exempt from the Indiana state civil rights laws because of its status as a religiously affiliated school. And the court ultimately held that the student's discrimination claim related to education and did not interfere or implicate interference with the school's religious creed. The court went on to note that although the Indiana legislature chose to exempt private religious institutions from ICRC's jurisdiction with regard to employment discrimination, it did not choose to provide the same exemption for discrimination relating to education. So the agency's authority to investigate and possibly litigate educational discrimination claims is actually broader than our authority to pursue employment claims. And as you can also see from this decision, the court took a very broad approach to what is related to education. In that case, you're talking about being a possible discrimination relating to being able to participate in extracurricular activity. And that was still subject to ICRC's jurisdiction and was considered an equal opportunity to equal access to educational opportunities. But in a subsequent decision from the Indiana Supreme Court, the court actually held that the student, that the complaint was not related to education, in that it was dealing with access to an event that just happened to, I think, occur on school grounds, but it had nothing to do with the school itself. It was not an educational opportunity. But again, that goes back to that theme that a complaint alleging unlawful education discrimination needs to link that alleged discriminatory act to education in some form. Some final food for thought things. Documentation. This applies to all claims, of course, all discrimination claims, but having emails of a particular series of questions or issue, or documenting the issue, can make an investigation so much easier, or easier to prove that something did occur or did not occur. For schools and school administrators, it's always important to constantly review and revise policies and procedures on a regular basis. Again, kind of going back to that example earlier about a policy having a chilling effect, and to ensure it doesn't, constantly checking your enrollment and seeing if a protected class is having a noticeable drop in enrollment, because maybe a policy unintentionally is creating that disparate impact on that protected class. Third, evaluate before you implement. The first idea is not necessarily the best idea. It's always good to carefully think out a new policy or procedure, and just think about these things about, like, well, could it impact a particular protected class, even though that's not the purpose of that policy. But it's easier to do that in the front end than find out on the back end that you've come up with a policy that might have discriminatory impact. And then finally, consistency. If you have policies and procedures, make sure that they're being applied consistently, because anytime that you get away from inconsistent implementation, you're likely to have a possible civil rights violation occur. So that's it for my presentation, and I'm going to turn it over to Dr. Kelly, and I believe we're going to have some Q&A, and I will stop sharing my screen.
Yes, we've got several questions in the Q&A. Let me ask one before we look at those questions. The Indiana Civil Rights Commission has a different role than the U.S. Department of Education Office of Civil Rights. How are your office and that office connected?
Um,
or are they connected at all?
so there is no official connection. Our federal partners, as you had identified at the beginning of this presentation, are the EEOC and HUD. But of course, we look to offices such as that office for guidance. The Indiana courts have repeatedly held that it's appropriate for both agency action and subsequent litigation to look to federal guidance. It's appropriate for us to look and rely on federal guidance, even if it's not binding on us, but it is appropriate to refer to that. So no official link, but of course we monitor their guidance and litigation to assist us in our enforcement of the Indiana laws.
Okay, now let's go to the first question in the chat. Early on, you were talking about immigration and citizenship issues. So the question is, this is from Cynthia Murphy, does citizens reflect an immigration status or merely verifiable residency in the state of Indiana? What's happening with students who are from an immigrant status who may not want to be identified but have legitimate issues?
So it's always hard to address hypotheticals, and I'm not trying to be difficult. It's just every situation is so unique, and you know, if it's hard to say what would happen in that situation, but of course, you know, we would look to whether or not a discriminatory act occurred first before ever considering anything like that. And then if a determination had to be made about whether or not there's jurisdiction over that individual, we would address it on an individual basis in every case. So it's just hard to say. It's hard to answer a hypothetical.
What about the citizen and residency requirements? How are they connected?
I'm not sure if I understand the question.
Well, the question was, let me see, if I can go back there.
I mean, I think the general, oh, I'm sorry.
Does citizens reflect an immigration status or merely verifiable residency in the state?
I'm not familiar with any requirement that would address that issue. So I think we would accept that complaint and pursue an investigation in that scenario.
Okay, thank you. So in schools where discipline rules may apply disproportionately to students who are suspended, would that be a cause for a civil rights complaint?
So the short answer, it depends. I know people hate that answer, but it's so often the appropriate answer. It depends on various factors. Again, you know, are we talking about a protected class? You know, or is that, or are multiple protected classes being treated similarly? Or are all students in that particular school receiving disciplinary actions at the same rates? If there is a discrepancy, all I can say is that might be likely a basis for a complaint and subsequent investigation. But you know, the school might be able to demonstrate some justification for, you know, why this particular discrepancy or disparate impact is occurring. Of course, it's one thing to identify disparate impacts, but then there's the possibility that there is an explanation about why it's happening, which is, you know, permissible under law. So in that scenario, it certainly could give rise to a complaint and investigation, but of course, where it goes from there is just depending on the facts for that individual case.
Here's another question. This comes from Carol Craig. In schools where Black children attend every day to a failing school and continually get below proficiency on standardized tests, is this a reason for filing a civil rights complaint?
Again, I don't like to answer hypotheticals. You know, when you're talking about proficiency and academic performance, those are issues that might be better addressed by the Indiana Department of Education. It depends on the facts. I mean, I always encourage individuals to call our office and submit an inquiry, at which time we can review the specific facts of that particular inquiry and make a determination if we do have authority to pursue an investigation.
Okay. Next question. So far, we have avoided mentioning the gender-based issues, such as transgendered students, LGBTQIA+, etc. Would the failure of a staff to use the preferred pronouns of a student fall into harassment or hostile environment?
So that, of course, is a very much discussed topic. And I know that at the federal level, there are a number of guidelines that are being developed under Title IX of the laws I mentioned earlier. And I can't say I'm familiar with the current status of all of those rules and regulations. And I know I keep saying this, I sound like a broken record, but it just depends on the scenario. And if you have a concern, I would encourage you to contact the ICRC because until we have complaint, in front of us, we can't really make a determination if we have authority to pursue the matter.
All right. The next question are private religious schools exempt from civil rights laws with regard to their employees? It seems federal civil rights laws would supersede Indiana policy.
So I can't comment on the federal side of that, but as far as employment, there is actually going back to the Indiana Court of Appeals decision I was discussing earlier, where the court noted that there are exceptions in the Indiana civil rights laws regarding employment issues and whether or not the employer has a particular religious affiliation. But that exemption does not apply to access to education under our laws. So it is possible that a particular religiously affiliated institution might be exempt from employment civil rights laws, but the education protections are more expansive and cast a wider net.
We've got several comments that thank you for this important information that you provided today. Indiana has laws. This is from Adrian Mabry. Indiana has laws which state that students who have been designated as having high ability may receive adapted services education in their school building. However, they've named IPS district, but there could be other schools too that leaves how these services may be implemented to the individual schools. Are you aware of any cases brought before the Indiana courts because a student was not provided targeted high ability education in their school?
No, I'm not aware of any case law. That doesn't mean it doesn't exist. That's just not a particular issue I've been tracking myself. And I think that particular issue might be something that the Department of Education could assist the individual with more so than the Civil Rights Commission, because that sounds like more about maybe more curriculum-based question, where as opposed to, the Civil Rights Commission is focused on access to education.
Well, we've covered most of the questions that were in the chat, and thank you very, very much for this informative presentation. Once this session ends, you will be redirected to the survey session survey. Please complete the survey because your answers to the survey help us with planning for next year. Please enjoy the rest of your time at the Indiana University Education Conference hosted by IBE. And thank you again, Tim, for your presentation.
Privileged to be here. Thank you.